This is the case of Sylvia De Leon versus the Court of Appeals. In this case, private respondent Jose Vicente De Leon and petitioner Sylvia De Leon got married in 1969 and begotten a child in 1971. Sometime in October 1972, a de facto separation between the spouses occurred due to irreconcilable marital differences, with Sylvia leaving the conjugal home. Sylvia went to the United States where she obtained American citizenship. In November 1973, Sylvia filed with the Superior Court of California a petition for dissolution of marriage against Jose Vicente. In the said divorce proceedings, Sylvia also filed claims for support and distribution of properties. It appears, however, that since Jose Vicente was then a Philippine resident and did not have any assets in the United States, Sylvia chose to hold in abeyance the divorce proceedings and, in the meantime, concentrated her efforts to obtain some sort of property settlements with Jose Vicente in the Philippines. Thus, on March 16, 1977, Sylvia succeeded in entering into a letter agreement with her mother-in-law, private respondent Macaria de Leon. Subsequently, Sylvia and Jose filed before the then Court of First Instance of Rizal a joint petition for judicial approval of dissolution of their conjugal partnership, which the court approved. On the other hand, Macaria filed a complaint in intervention. She assailed the validity and legality of the letter agreement, which had for its purpose, according to her, the termination of marital relationship between Sylvia and Jose Vicente. The trial court rendered judgment, declaring null and void the letter agreement dated March 16, 1977, which the CA affirmed, hence the petition. It is important to note first what the third paragraph of the letter agreement states. In consideration for a peaceful and amicable termination of relations between the undersigned and her lawfully wedded husband. Accordingly, Sylvia insists that the consideration for her execution of the letter agreement was the termination of property relations with her husband. On the other hand, Macaria and Jose Vicente assert that the consideration was the termination of marital relationship. The issue here is whether or not the letter agreement is valid. The court ruled in the negative. The court sustained the observations and conclusion made by the trial court, which stated that, in the letter agreement, the parties contemplated not only to agree to a judicial separation of property of the spouses, but likewise to continue with divorce proceedings. If taken with the apparently ambiguous provisions regarding termination of relations, the parties clearly contemplated not only the termination of property relationship, but likewise of marital relationship in its entirety. Furthermore, it would be safe to assume that the parties, not having specified the particular relationship which they wanted to peacefully and amicably terminate, had intended to terminate all kinds of relations, both marital and property. While there could be inherent benefits to a termination of conjugal property relationship between the spouses, the court could not clearly perceive the underlying benefit for the intervenor insofar as termination of property relationship between the petitioners is concerned, unless the underlying consideration for intervenor is the termination of marital relationship by divorce proceedings between her son and his wife petitioner. One of the provisions in the letter agreement stated that it is the objective of this agreement that said divorce proceedings in the United States will continue. There is merit in concluding that the consideration by which intervenor executed the letter agreement was to secure freedom for her son, especially if a separate agreement signed by petitioner Sylvia to consent to and pardon Jose Vicente de Leon for adultery and concubinage would be considered. The court therefore finds and holds that the cause or consideration for the intervenor Macaria de Leon in having executed the letter agreement was the termination of the marital relationship between her son and Sylvia de Leon. Marriage is not a mere contract but a sacred social institution. Accordingly, the court held that the intervenor's undertaking under the letter agreement premised on the termination of marital relationship is not only contrary to law but contrary to Filipino morals and public policy. As such, any agreement or obligations based on such unlawful consideration and which is contrary to public policy should be deemed null and void.